So if I could have your attention, I have the pleasure of bringing this wonderful day to order. And my name is Phil Weiser. I'm the dean here at Colorado Law. And for those who don't know Colorado Law's history and engagement with the Native American community, I need to start on a few special notes. We have two awesome, and I mean this with underlines under it, co-chairs of our American Indian Law program. That's Kristen Carpenter and Carla Fredericks. Let's start by acknowledging both of them. And both of them are the beneficiaries of, in Yiddish we would say great yichus, which means kind of heritage. And with great yichus comes great responsibility. The heritage that they have here at Colorado Law has many critical partners. For those who aren't familiar with NARF, the Native American Rights Fund, the great work that John Eckelhawk is doing, the partnership between NARF and Colorado Law is critically important to us. NARF's first director was David Getchis. Rick Collins and Charles Wilkinson, both in the House today, had worked at NARF. Another director, Tom Fredericks, will be here today. So when you think about it, and John, those are the three directors, right? David, Tom, and you. So the NARF family and our family are one. Also, Tom, who will be here today, had been the Assistant Secretary for Indian Affairs. And that was a position that is now held by Kevin Washburn, who's part of our extended family. I'll introduce Kevin in a minute. I also want to acknowledge all the students who've come through and been a part of our community. Some of whom have made historic contributions, Vine Deloria comes to mind, but many of whom are working in this field. That's so important because over the last 40 years, there has been a remarkable change in this field of American Indian law, and we need to be and have been and will be centrally involved with all of you. We have a clinic that's one of the few in this country. That's an American Indian Law Clinic, and having Carla Fredericks come back to Colorado to direct it is really a special homecoming for us, and we're so happy to have her as part of our community. What's wonderful about today's conference is it pulls together this tradition that I've been talking about with another important tradition, another tradition that David and Charles have been central in, which is natural resources and being a good steward of our resources. Brad Udall is here. He's the director of the Getchis Wilkinson Center. You'll hear from him later. And the Udall family is also part of the Colorado Law family. We have one of their prodigy here with us as a student. We have one of them as our director and one as our senator. So we're very much appreciative of all their involvement. The Getchis Wilkinson Center is a new name for a new era, formerly known as the Natural Resources Law Center. After David passed away, there was a visioning process about the next 30 years, and this name represents a legacy that we're building on, that David and Charles have built. And this issue that intersects that natural resources tradition with the American Indian law tradition is about how resources are viewed, not just here, but around the world. And this concept, interestingly enough, has more even traction around the world than here, but obviously is a very important theme, and we'll hear lots around it. There are a number of the specific panels we hear about today, and we believe we are well situated to continue to be a thought leader. The people who put the conference together, I've already mentioned, but I'll say again, Brad Udall from the Getchis Wilkinson Center, Kristen Carpenter and Carla Fredericks, American Indian Law Program, and no worries. And we really are situated for a great set of conversations. This type of community engagement is something that we at Colorado Law take very seriously. And for all those who are supporting the American Indian Law Program, and for all those who will support the American Indian Law Program, we thank you and appreciate your support. So I'm not going to have the pleasure of introducing Kevin, although you're in for a treat. Instead, I can introduce Kristen Carpenter, who I've already talked about, and who will take it from here. So Kristen, please take it away.
Good morning, everyone. It's great to see you, and thank you to Phil. I do want to acknowledge Phil as the Dean of our law school. Phil's signature is to be an innovator in legal education, and with respect to our American Indian Law program and our Getches Wilkinson Center, he's always encouraging us to look to the future, to see what's coming in our fields, and to be broadly engaged with the community. And I think in an event like this that's cross-disciplinary and has a wonderfully broad audience, you can really see his imprint. So thank you. I also just quickly want to reiterate thanks to my close colleagues, Carla Fredericks, Brad Udall, Rick Collins, and Charles Wilkinson, who all worked on the vision and execution of this event. Each of them is a notable leader in their fields. This is an incredible place to teach and work and be mentored, and to have these colleagues as friends is something I'm grateful for all the time. And I'm sorry, I'm advancing this PowerPoint here. I'll just close that. And I should mention, too, the Getches Wilkinson Center Fellow, Julia Guarino, our American Indian Law Program Fellow, Kelsey Peterson, and NALSA member 1L, Lauren Goschke, as many as other student volunteers who've put a tremendous amount of time and energy. They were up till midnight last night, stuffing folders and et cetera, and without them, none of this could have happened, as well as to our sponsors, whose support we deeply appreciate. This conference had several inspirations. First, this is the era of Indigenous peoples' rights. After decades of advocacy and effort in international forums, Indigenous peoples have secured recognition through instruments, including the United Nations Declaration on the Rights of Indigenous Peoples, with guarantees of self-determination, cultural and religious freedoms, and social and economic development. So we turn now to implementing Indigenous peoples' rights. And in this period, there are many questions about the provisions of the UN DRIP and many other instruments, what they mean and how to operationalize them. One of the terms that we're really still working to understand is this concept of free, prior, and informed consent, trying to understand the scope, the demands, best practices as they relate to self-determination and the well-being of Indigenous peoples more broadly. So in this conference, our aim is to look at the theory and practice of consent and then to consider it in the specific areas of natural resources, climate change, cultural heritage, with an eye to advancing potentially transformative practices in international and domestic law. We've been very fortunate to assemble an impressive slate of speakers, and I thank each of you for traveling to be with us. Some of you missed Halloween with your kids in order to be here, so thank you. For our opening speaker, we are honored and privileged to welcome Kevin Washburn, the Assistant Secretary for Indian Affairs in the Department of the Interior. In this position, Assistant Secretary Washburn is responsible for administering the department's trust responsibilities to individual Indians and to tribes, and promoting the self-determination of 566 Indian tribes across the United States, which is basically to say he has one of the most notoriously difficult jobs in Washington. But Assistant Secretary Washburn leads in this position with grace and sensitivity, stemming in part, I think, and I've known Kevin for a long time, from the background and experience he brings to the task. As an enrolled citizen of the Chickasaw Nation, Assistant Secretary Washburn grew up within his community. He went to the University of Oklahoma. He then went to Yale Law School, and following law school, clerked for Judge Canby on the Ninth Circuit, the leading judicial expert in Indian law. Kevin then continued his service in the government as a trial attorney in the Indian Resource Section of the Department of Justice, as an assistant United States attorney prosecuting federal crimes in New Mexico, and as general counsel for the National Indian Gaming Commission. He then brought this substantial experience into academia, where he was a professor at the University of Minnesota and then at the University of Arizona, two great Indian law powerhouses, publishing a number of very important articles in criminal justice and gaming law as they pertain to Indian country. He then became the dean of the University of New Mexico Law School. Now, as Assistant Secretary for Indian Affairs, Kevin is working on many important initiatives, from economic empowerment to self-governance, including his communication and consultation efforts with tribal officials. And we are very grateful for his presence here. Kevin will make some remarks and then take questions and answers. Thank you.
Well, it's a real honor to be here. The Law School of David Getches and Charles Wilkinson and Rick Collins and so many other important contributors to our field. and the hometown of Narf, which is such a great, also such an important part of this law school. So it's a real honor to be here, and I thank you, Kristen, and your colleagues for inviting me, and Dean Weiser as well. It's a real honor to be here. One of the signal accomplishments of the Obama administration has been to change American policy in regard to the UN Declaration on the Rights of Indigenous Peoples. And I think, and it really, in this area generally of free, prior, and informed consent, because of course, one of his first actions was to institute the executive order on consultation with Indian tribes that I'll talk a little bit more about in a little bit, but then signing on to the UN Declaration on the Rights of Indigenous Peoples, which I can't say very well because I routinely refer to it as the DRIP, which doesn't seem an appropriate lofty word for what it is. But we call it the DRIP around the Interior Building, and so if I say that, I'm not being disrespectful. It's just a shorthand. I'm really proud to be part of the administration that was involved in this way. Professor Carpenter's timing is perfect here. Today is the first day of Native American Heritage Month, and it's really nice to spend the first day of, while we are thinking about our Native American heritage, also thinking about our future. And I think very much the DRIP and free, prior, and informed consent is very much about the future of where Indian and indigenous policy needs to go. And it fits very well with our federal norm of consultation, but is in fact even better. So first I want to talk about those two things, the free, prior, and informed consent and consultation. And then I want to pivot a little bit to the other side of the ledger, where the tribe is not merely consenting to something, but is actually driving the agenda, making the decisions. And because that's really where my expertise is more, and so I'm going to pull a fast one a little bit. That said, let me make a disclaimer up front. The UN Declaration of the Rights of Indigenous Peoples is an international policy, and I sometimes get in trouble in Washington when I stray out of my lane. My lane is Indian Affairs, and this certainly has a lot to do with Indian Affairs, but I get in trouble sometimes, and so I want to do an appropriate disclaimer. Just to give you an example, shortly after I arrived in my job, one of my mentors, Charles Blackwell, passed away. And Charles Blackwell was my tribe's representative in Washington, D.C., and had the title of Ambassador to the United States from the Chickasaw Nation. And I didn't know what to do, but my public affairs person said, well, you could put out a statement. We frequently do that when someone passes away. And so I put out a statement, regretting the loss of Ambassador Charles Blackwell. And I quickly got a call from others in the government saying, you're not the Secretary of State. You're the Assistant Secretary of Indian Affairs. You're not the one who gets to recognize ambassadors around here. So I said, okay, I'm sorry. I didn't mean to, be doing anything wrong. I said that, if my tribe called him ambassador, or any tribe called him ambassador, I felt I had to use that term too. I mean, I was not sure that I had a choice. If they'd called him the Grand Poobah, I would have used that term, I suppose, which he would appreciate. But I will try to stay in my lane today as I talk about this principle that's an important domestic principle, but also an important international principle. The UN Declaration of the Rights of Indigenous Peoples was finalized and adopted by the UN in 2007, and it was formally supported by President Obama in 2010. And it's obviously an international document of principles drafted broadly to apply globally. As I heard one tribal leader put it eloquently, I thought, it's a law that seeks to protect, or a principle that seeks to protect grandma's law. For those of you who come from tribal communities, you know what this means, but it basically addresses the rights of indigenous peoples to continue practicing their cultural beliefs. To be free from coercive actions by states, and to have their rights to lands, resources, and security, and homelands. At the end of the day, grandma needs to be free to collect medicinal plants, to live as she always has, to speak her own language, and use the land as she always has lived, and to have access to all the necessities she needs to live a long and healthy life like her ancestors and her children. Now, domestically, I don't think that any country in the world is probably fully living up to the principles that are in the Declaration. And it has been even, President Obama says that it's aspirational. We aspire to meet the terms in the Declaration. And most countries haven't fully internalized in their domestic laws the concepts that are in the Declaration. And President Obama noted in regards to the Declaration that, and this is a quote, "What matters far more than words, what matters far more than any resolution or declaration, are actions to match those words." And so the President knows that what he will be judged upon is how well did he take those actions to match those words. So I'd like to put this in context a little bit. The DRIP is a very important document because some countries don't afford very many protections to indigenous peoples, and I suspect that all countries, including the United States, occasionally fall down on those principles and fail to meet them. And these are principles that all the countries have assented to, so that's a problem. In the US, prior to the Declaration, we had begun developing more robust notions of consultation, of course, and President Obama's 2009 executive order, issued in the first year of his first term, famously was broad. It required federal agencies to consult on any question of policymaking that implicates tribal interests. That was the wording, implicates tribal interests. That's pretty broad. There's a lot of things that the federal government does that implicates tribal interests. So that was hailed. Executive Order 13175 was a big step forward, and President Obama, very carefully required every agency to meet this executive order by preparing their own plans on how they are going to conduct tribal consultation, and in a way that's relevant to that agency's work. I think the Declaration was indeed a further step forward. Again, I'll defer comments globally, but I can opine in a domestic context from a national perspective. And since I'm the first speaker, perhaps I should give a little bit of an overview to what free, prior, and informed consent entails. And if I miss anything, there are far better experts coming up that can fill in. But let me just quickly say, I think, and maybe that's obvious, but plain language interpretation of free, prior, and informed consent. And it looks a little different than consultation. Let's break down what it means. First, any decision made by the tribe must be made free from any kind of coercion. In other words, decisions must be made between negotiating partners operating on sort of a level playing field. Next, there must be prior and informed consent, meaning that the tribe ought to know all the details about the matters that it's discussing. And those details need to be made available to the tribe so they can make a fully informed decision. And the final decision is conveyed through the consent of the tribe. In other words, if there's no consent, there should be no action. And while we are exceedingly proud of the tremendous step forward we have made in the area of consultation, I think this is one of the biggest differences. This last part is the biggest difference between mere consultation and free, prior, and informed consent. Under consultation, as I have frequently reminded tribes and been required to remind tribes when they've come in, mostly to complain about other agencies, but it does not give tribes a veto power. It ensures that the agency has asked the tribe their views and respected them in that way by bringing them in and asking their views, and then also taking their views into account when it makes a decision. And those are very, very important tasks, but they don't rise necessarily to a veto. And free, prior, informed consent, I think, could be likened much more to a veto type power. If there's no consent, there's no action. So I think that free, prior, and informed consent is something much more than consultation. So, in sum, the Declaration has moved the world forward in providing a principle broader than consultation to which we must aspire. And the people who worked so hard for so many years to achieve the passage of the Declaration in the UN, some of whom are here in this room, deserve great credit for advancing civilization and indeed humanity, and they deserve great credit. So, it's an important concept that we must all aspire to. Now, I've already said that I think the U.S. may occasionally fall short of the aspirations of free, prior, and informed consent, and there's usually a line outside my office of people willing to explain to me just how. That's the life of an Assistant Secretary for Indian Affairs. And explaining to my colleagues in other agencies is something that I spend a lot of time doing, trying to straighten them out when the tribe comes to complain. And people don't like to see me coming in there. Other agency officials don't like to see me walking into their office most times. you're necessarily focusing on situations where the tribe is unhappy, and that's one of the that's one of the issues. The need for consent is important. I had a short conversation last night with Tim Coulter, who's one of our nation's most outstanding international indigenous lawyers, and he sort of brought this point home to me, and I think he's going to talk a little bit more about that later today. And I know a little bit about the concept of consent from my life as a law professor. And this may put way too sharp a point on it, but the place where I've taught consent most often was in the law of rape. The law of rape often deals with, whether there was consent or not. And so I've spent many hours in classrooms working on this with students. And it's not an ideal situation when tribes are in the context of being a passive participant in action or in a defensive posture, and that's what we're talking about when we're talking about the issue of consent. And it's an exceedingly important subject, and I'm glad that it's going to be a focus for the whole day in various important contexts. But I'm going to pivot just a little bit to areas where it's not the tribes that are passive actors in the action, but where they're driving the agenda. And that's really where I think the United States can be most proud. So it's an appropriate thing for me to work on or to talk about. I was inspired to work for this president, not because of my interest so much in issues of consent. In fact, if you want to make a difference on those kinds of issues, you'd be better off in another agency that's sort of going like this with tribes more, that's confronting tribes around difficult land use issues or something. I was inspired to join the administration for very different principles, and those principles relate to self-determination and self-governance for tribes. And it's sort of the other side of the coin of the situation where we have consent or issues of consent. And since it is Native American Heritage Month, let me tell you a little bit about my personal story that has informed my own passion for self-governance. I grew up mostly within the former boundaries of the Chickasaw Nation in Oklahoma, as Kristen recognized in introducing me. And for much of my childhood, my mother was a single mother raising 3 kids. And despite her hard work, we nevertheless were very poor. And with 3 kids in 3 different grades, we were sick a lot, especially my little brother who had asthma. And nutrition may have something to do with it because we drank Kool-Aid all the time. It wasn't a healthy lifestyle, I can't say. And perhaps some of you had similar childhoods, but at any rate, we spent a fair bit of time in Indian Health Service hospitals. In my case, in Tallahena, Oklahoma, and Ada, Oklahoma. And it was a dreary existence. I was there when the Carl Albert Indian Hospital in Ada, Oklahoma opened up. And it was nice when it first opened up, but we spent a heck of a lot of time there, and it sort of became shabbier and shabbier and shabbier. And the reason we spent a lot of time there was we were always waiting for our appointment, and they rarely happened on time. We often spent hours and hours waiting for an appointment with the doctor at the hospital. And like I said, it became kind of a worn down and crummy place. And in the late 1980s or early 1990s, the governor of my tribe, Governor Anatubby, who still runs our tribe, decided that he was going to take over the hospital, which is lawful under federal 638 contracts, self-determination contracts, or self-governance compacts. And it was quite controversial when he decided to do this. He was criticized. I remember my aunts and uncles saying, "That's crazy. There's no way that my tribe can run this better than the federal government can. That's just crazy. This is going to be a disaster. We're going to lose health care." And it was an immense risk for him as a politician, as the governor of the tribe, to do this. And frankly, there were the criticisms were placed to some degree with self-loathing, I think. I mean, we just didn't think we could do this. But the governor believed in us, and the governor took over the hospital. And a funny thing happened almost immediately. I was away by this point. I was off to college and law school. But the service improved. The service improved immediately. I got this call from my mom one night, shortly after the tribe took over the hospital, and she said she'd gotten a call from the hospital, and they said, "Don't come in for your 11 a.m. appointment. Come after lunch, because we're running really late today. There's no reason you need to be sitting around here waiting. You can just come later." And you know, pretty soon they remodeled the place. You know, it didn't look so shabby anymore. And I'm proud to say we now have a brand new hospital that's just immaculate in Ada, Oklahoma, but that the tribe built. But at any rate, there were a lot of physical improvements, there were a lot of service improvements, and I'm confident the medical care improved as well. Although one of the things the tribe did was hire most of the IHS doctors who, you know, wanted to stay. And so it was a pretty smooth transition. If it hadn't worked, I guarantee you that Governor Anatubby would have been thrown out in the next election if it had been a disaster. And in fact, if it even had taken a while to get better, I think that's what would have happened. But he did a better job running the hospital. The tribe did a better job running the hospital than a federal agency did. And why is that? Well, it's because the governor's job depended on it, I think. It's a simple matter of accountability. You know, civil service employees, federal civil service employees have tremendous protections, and those are good things. But it's always better when the tribe's running things, in my mind, because tribes are just much more accountable to the community they serve. And so, if you've read any of my writing, you know that's sort of my point. That's why I think this is important. But this is personal experience for me and my tribal heritage, and left me with the firm conviction that tribes can run programs better than the United States can. And so what I bring to my job is the gospel of self-determination and self-governance. And it is a prevailing policy of our country, and I'm really glad to see that it's taking root so well. Over the past few years, the United States has been able to pass several key pieces of legislation. I think that would stand us in good stead if we were compared to almost any other nation in the world, all of which acknowledge tribal government autonomy in a greater degree than ever before. And indeed, in this realm, I think the United States probably exceeds every other country in the world. I mentioned 638 contracts and self-governance compacts for Indian Health Service and Bureau of Indian Affairs work, but we have all sorts of other contracting regimes where tribes contract for these sorts of things. 477 workforce development programs, 297 tribally run schools in which tribal school boards are replacing Bureau of Indian Education federal officials. NAHASDA, which is for housing, where tribes run housing on Indian reservations. Hundreds of millions of dollars of roads fundings that are performed by tribes. It goes on and on and on, and honestly, I've complained because there are so many different programs that foster self-determination and self-governance that Rube Goldberg himself couldn't come up with a more complicated way to achieve self-governance, but nevertheless, we do have very robust self-governance programs. We also have a lot of expanded substantive programs in which tribes are not, consenting to federal actions, but they are indeed in charge of the decision making. I went to dinner last night with an old friend, Alfredo Maitri, who works for EPA, and in the 1980s and 1990s, we got a whole new laws that treat tribes as states in the environmental context, which is so important. In other words, it's the tribe making the decision, not simply consenting to someone else's decision. Another is the Tribal Law and Order Act, passed in 2010, which expands tribal criminal jurisdiction to felony offenses so that tribes, rather than feds, can make felony charging decisions. Another, of course, is the Violence Against Women Reauthorization of 2013, which extends criminal jurisdiction by tribal courts over non-Indians in certain circumstances. That's truly remarkable. Another, in my world, in the area of economic development, is the Hearth Act. And so the approval authority for leases can now be the tribe rather than the federal government. And so it improves economic development dramatically. And the final one that I'll mention is the reauthorization of the Stafford Act. So now a tribe doesn't have to beg a state to declare an emergency when there's been a disaster. The tribe can declare a disaster and go straight to FEMA and get assistance. So the list goes on and on. The good thing about the list is it seems to be growing dramatically. We are really, truly in an age of expanded self-governance. Other countries have their own histories with their tribal peoples, and like those, they develop over time, and they involve a lot of hardship. And our history has a tremendous amount of hardship, but we're at a very good space. We have tribes that are doing everything that the federal government has ever done on Indian reservations, and I dare say, often doing it better. And I also dare say that I think the United States is at the forefront of this movement and this development. So these programs in which tribes are back in the driver's seat are maybe the positive side of the equation, and they certainly aren't in the driver's seat for all programs, and that's why consent is such an important principle. But the self-governance approach is beneficial in many, many ways, but let me just mention three. First, it's an exercise of sovereignty. It reflects tribes being governments, not passive players in another actor's storyline. Secondly, it allows tribes more flexibility. Tribes are able to make even the small decisions that can make a difference in providing services, and that's important. They better serve Indian people on a day-to-day basis. Third, it builds tribal capacities. It creates more professional tribal governments, makes tribal governments even stronger, and thereby decreases the dependence on other sovereigns. So the principle of consent is very important, but it's less needed if the tribes are running the programs. So, and I don't want to be a Pollyanna. We do have our problems in the federal government. We have our problems in governing. In my role, I tend to see things most when they go wrong at the tribal level. When often when a tribe is running a program and it doesn't go right in some way. I won't say it hasn't diminished my enthusiasm for self-governance because it kind of proves that it's nothing's perfect, right? So you'd expect to see some things go wrong. I used to kind of complain about these dysfunctional tribal governments that if we just get these dysfunctional tribal governments working better, everything would be good. But along about October 5th or October 6th, or maybe it was 7th, 8th, 9th, 10th, somewhere along in there, of the federal government shutdown, I publicly vowed that I would stop using the words dysfunctional tribal government. Those of us who live in glass houses can't be throwing stones. And the shutdown is easy to make light of, but the truth is we haven't passed a government budget in years. We've been operating on continuing resolutions. It's just, it's deplorable. And I'm a recidivist in the federal government. I was there during the 95-96 shutdown too, and so I've been through this before. But we are as dysfunctional in many respects as any government in the world. And tribes had a tough year this year, especially the ones engaged in self-governance because we had sequestration, and so my budget was cut 5%, and I had to pass that 5% cut along to the tribes that I had contracts with as well. So everybody got cut 5%. Now, the shutdown, in some respects, was a positive it was not a positive in any respect, so let me rephrase that. But the tribes that have self-governance programs could continue providing services to their people if they had money. I mean, if they had stretched their money out after it had been cut 5% and they still had some money, they could continue operating, whereas federal officials were sent home. I had to furlough all of my employees unless they had something to do with imminent life or health or safety. And so that was, in some respects, a victory for those tribes that had made the choice to go self-governance because they could continue providing services. So I'm glad to see some students here today because I think it's students who will chart the path forward about what does this actually mean. What does the Declaration mean and how do we use it? What does consultation mean and how do we use it? The Declaration, even consultation is not necessarily legally binding in all cases, and so it's going to take creative lawyers to figure out how do we make these things more binding and ensure that the government follows them. And so students, I think that the lawyers that are coming out now will be the ones to get to figure that out as they go forward in their careers. Globally, the UN has called for a plenary meeting to be known as the World Conference on Indigenous Peoples in New York City in September 2014, with the goal of reviewing best practices for how the Declaration works. And this will be, I'm sure, an opportunity to think of through some of those best practices and to help to inform that meeting. But let me just say, the Declaration is getting cited a lot, and it's really important. It is starting to become a very important tool for advocacy. I've seen comments submitted by tribes to the United States Treasury on tax policy that cite the Declaration to good effect. James Anaya, Special Rapporteur, and my former colleague, recently cited the Declaration in talking about the Baby Veronica case. and the need to protect Indian children. And so there will be great uses for the Declaration, and it will continue to breathe important life into a lot of different arguments. And to the students, I would say your job is to, as an upcoming practitioner, is to be a zealous advocate and find new ways to use the Declaration and the principles that we will talk about today to advocate for free, prior, and informed consent, and to make sure it's incorporated more carefully into U.S. law. The truth is the document's still relatively new, and we have a lot to learn about it. And so I'm grateful for this conference to give us that opportunity. In closing, I'd like to add that I support the idea that the Declaration itself and the FPIC clause in several places underscores important moral obligations domestically in the United States, obligations to account much more carefully for indigenous cultural heritage, to be more responsive to concerns expressed by tribes in all matters implicating their interests, and to be more creative in avoiding negative impacts to tribes. And finally, I commend the law school for taking such important steps to raise awareness about the Declaration and its meaning in our world. So, thank you for listening to me. It's always an honor, and why don't I stop there and take some questions.
Thank you, Kevin, for the stirring talk, as always. I'm not sure if this is on, but we have time for one or two questions, and I'll just take a volunteer. Okay, great.
Good morning, Mr. Assistant Secretary.
Good morning, Wes.
Always good to see you.
Thank you.
In talking about natural resources and energy, you well know my main focus is always water. And over the years, we've seen a lot of things happen. I come from Wind River, where we've had the Bighorn adjudication. And really thankful for David Getchus and Charles Wilkinson for the work they did with us in developing our tribal water code. But my question regards the federal government's obligation to protect those rights on behalf of tribes. And just seemed like over recent years, we haven't done a very good job of doing that. And so I'm hoping you're going to be in here for the rest of the administration, but I'd sure like to get your thoughts on what we're going to see from your office relating to the protection of federal Indian Reserve water rights.
Thank you, Wes. It's a great question, and let me tell you, it's quite a challenge. I feel like we have not done enough over the years to protect Indian water rights, and I've worked on those issues some in my past with Chairman Maitre for the Las Vegas Paiute. One of my first cases as a lawyer was trying to get water rights for the Las Vegas Paiute tribe, and so I care about those issues deeply personally. I will tell you, I'm missing a meeting today in Washington where we are trying to figure out how we're going to come up with more than $1 billion that we owe because of a bunch of water rights settlements we've done recently. And we want to keep doing water rights settlements. We want to, it needs to happen all over the country. They are very, very expensive, and it's starting to dawn on me that it's going to be hard to keep doing major Indian water rights settlements because of the cost and the fiscal climate we find ourselves in. We supported just a couple of months ago a water rights settlement for the Blackfeet tribe. That's the federal price tag is around $400 million for that. And I think there was a time when, hundreds of millions of dollars, you could find it, and it's getting a lot harder to find that money. And so I'm a little bit demoralized just by the fiscal climate we're in. We are still continuing to support those. We testified in favor of the Blackfeet settlement, and we need to be doing a heck of a lot more of this, but it's getting harder and harder to find the money. So I'm a little bit worried about it.
Another question or two?
Good morning. My name is Rick Williams. I'm Oglala Lakota, Northern Cheyenne. And is it possible that we could expect an executive order out of Obama regarding the implementation of UNDRIP before his term is up?
I don't know the answer to that. Let me say he certainly is. I think he's called on us all to implement it in our various ways in different agencies. And one of his most recent executive order was establishing the Native American Affairs Council, which solves a problem that we're kind of lucky to have in some respects. There used to be a time when tribes had one-stop shopping in Washington, D.C. It was the Bureau of Indian Affairs, and that was the only place tribes went for any kind of service. Now, nowadays, the Justice Department has a heck of a lot of stuff going on with tribes. Department of Transportation, Department of Agriculture, HHS, HUD, we've got all these agencies that are doing a heck of a lot with tribes. And many of them have tribal advisors to their secretary and that sort of thing, and offices, and EPA, and all these agencies now have these big Indian offices. And one of the things we learned was we weren't really talking to each other. We were all living in our separate silos. And part of the reason for the Native American Affairs Council was to get us talking much more to one another. And so that we are collaborating to solve problems in Indian country rather than trying to solve them ourselves, because especially as resources get more tight, we need to be working together more. So that's our latest executive order. I know that the President remains very proud that he signed on to the UNDRIP, and we were the last country in the entire world to do so. So I'm not sure if it'll make its way into an executive order or how he will seek to implement it further, but he's given us he's told us that he wants us to be carefully thinking through the principles anytime we're making decisions. And frankly, that falls on me, because I also find myself begging and cajoling other agencies to make sure they're paying attention to their obligations for consultation. And this is another arrow in the quiver for me when I'm talking to other agencies. So, thank you.
I think we can take one more question. We're just a minute over, but if there is one. I'm going to ask it myself. So, Kevin, it's just so amazing to have someone with your expertise and insights here, and I guess I have two levels of questions. The first is, and you just alluded to it, but to the extent that the Department of State represents us in international negotiations and diplomacy, and our community hasn't typically been that tapped into the Department of State, how would you advise us to sort of mobilize on all of these different issues we're talking about today when it comes to trying to have a voice internationally? And then the second part of my question is, and this too is a global question and you can respond to it at any level, but if we're thinking about implementation, and Rick mentioned executive orders, we could also be thinking about legislation, agency policy, all the way down to guidelines for particular agencies. What, again, based on your expertise and insights, would you recommend to us sort of strategically that we do?
Okay. Good questions, both. Hard questions, honestly. State Department just hired Jack Jackson from the Navajo Nation, who is a new Arizona state legislator, as their tribal advisor. And I think that's historic. I don't think they've had a tribal advisor before. So they're starting to get with the program. And that's a good thing. Occupying the State Department is a good thing for us to be doing. I will tell you that I went over to Geneva a few months back before sequestration to testify on the UN Convention on the Rights of the Child. And we are not a party to that convention. It's us and one other country in Africa, maybe Somalia, that refused to ratify the Convention on the Rights of the Child. But we did agree to one of the optional protocols on human trafficking, child trafficking. So we went over to testify because of that. And so I learned a little bit about the State Department. And they brought me because indigenous issues, some of our leaders have really pushed that as a good forum for advocating for our issues, and it's been good because they listen. That's a place, the State Department really wanted me there because they said, look, indigenous groups really get involved. That part of civil society really gets involved in these issues, and we need someone who knows these issues to be there to help us with those. And so I went. But I found when I got over there, though, there were like 12 people from the Department of Defense. There were, 10 or 12 from Department of Homeland Security, which also covers immigration. I mean, there were just a bunch of people from those units. I was the only person from the Department of the Interior. Even the Justice Department had 3 or 4 people, I think. And so it was a little lonely being there. We haven't really infiltrated that area. And I was actually like the second ranking person on the delegation, because I think there was an ambassador who's got the equivalent rank of assistant secretary, and there was one other assistant secretary. But it was it was not, these other departments had a lot more of the agenda and a much more of the portfolio, and so we need to be focused more. I mean, it's interesting that Indian Law Resource Center and people like that have really led in this area, and the rest of us need to lead in that area too. We need, as international law and international norms become so more important, we need to be more engaged in those. And so I think that's one of the things we need to do. And the appointment of Mr. Jackson at the State Department is a real plus. So strategies, insights. One of the things that I find that I'm surprised about, because everybody comes to me to complain about other agencies, and they rarely bring a copy of the executive. I know what it says, the executive order on consultation, but other agencies, they even have consultation plans. Every agency had to develop a consultation plan, so they've got one, and it's sitting somewhere in a drawer, but they don't necessarily go look at it very often. And so when you go talk to those agencies, that executive order on consultation that you can print out off the Federal Register in PDF, it's pretty impressive when you look at it. It's got Obama's signature down at the bottom. And if you carry that with you when you go meet with whatever the agency is that you're having trouble with, U.S. Forest Service or Fish and Wildlife or National Parks or whoever it is, take that with you and highlight the part where it says implicating important tribal interests, and make your case that this implicates an important tribal interest. And that doesn't happen as often as you would think. Maybe because it's not a law, it's not technically a law, it's merely an executive order, and lawyers, so they don't look at it so much, but it's pretty powerful. It's a pretty powerful document, and most agencies want to please their president, and they don't want you going to complain to the White House that they're not even following their own policy. And so that's a good stick for advocacy. So that's one little practice tip, I guess I'd call that.
Great. Well, thank you very, very much. We appreciate it. And we're going to move right to the next panel. If the panel on the theory and practice of consent would come on up, we're going to go right to that, and we'll do coffee after that panel. So thank you.
Good morning. This panel has a most appropriate title, Consent in Theory and Practice. Concepts of consent are basic to the law in many contexts and are fundamental to theories of democracy. Our panel will open today's discussion of consent in the context of the relationship between American Indian nations and the United States government. My job as moderator is to introduce the panel in the order in which they are to appear. Full bios for all of them are printed in your programs. This is a distinguished group, and if I had to tell you all the wonderful things they've done, it would eat up all the time. So I'm going to ask you to look at those bios. So now I'm going to introduce the panelists in the order in which they will appear. First up is Professor Matthew Fletcher from Michigan State University, who's now come disguised as a Red Sox fan. That's a new... Oh no, my mistake. Sorry.
You know, I'm from Michigan, right? The Tigers are my team. How could you have forgotten that? It was devastating.
You were just trying to look like them. Okay, all right. Tim Coulter will be second. He's founder and director of the Indian Law Resource Center in Helena, Montana. Third will be Calvin Lee, who practices law in the Navajo Nation's legislative branch. And fourth, Professor Rebecca Tsosie, who is on the law faculty at Arizona State University. That's all I'm going to do, and I'm going to sit down now.
All right. Well, good morning, everyone. Thanks to Rick for introducing me as a Red Sox fan, and thanks to Kristen for inviting me, and for everybody here at Colorado for having me back again. I guess I haven't insulted enough people so that I won't be invited back, so that's good. So I think I am tasked today with introducing sort of the political theory of consent, and perhaps expounding on a little bit and how it is, shows up a little bit in Indian country. I'm going to spend a lot of time talking about how ironic it is that we're going to be talking about consent, given the history of Indian affairs in this country. But that's really all. I think the more practical aspects will come out, I think, in our other speakers, and I think you'll see some pretty amazing talks. So consent, as you know, appears multiple times in the United Nations Declaration for the Rights of Indigenous Peoples, and it's been it's a good thing that it's in there. And so I will say, I guess I'll start off by saying, to some extent, fairly cynical about the notion of consent, in that if you think about it, and I was thinking about it in the context of the Assistant Secretary a few moments ago, consent can only go so far, and it assumes that there is somebody that is sort of superior, some entity, perhaps another sovereign, that is imposing its will, and your only defense against that will, perhaps as an indigenous nation or an Indian tribe or an individual, is to hopefully exercise the right of consent, free, prior, and informed consent. So we'll always have to keep that in mind, that the context of consent theory comes from the reality that there is a superior entity, perhaps a government, perhaps a doctor, who is exercising its will upon someone or something else. So consent theory, where our entire government in many ways in the United States is founded on this idea. The Declaration of Independence most famously introduced consent theory, or the notion of the consent of the governed, into our American legal vocabulary, and codified it to some extent. And you may recall shortly thereafter we had the Articles of Confederation, and then after that the United States Constitution, which forms the basis, the organic documents, the backbone of legal structure in the United States. The problem with consent theory, of course, is that no one has actually consented to the government. And it is truly a hypothetical consent. It's an implied consent. It's purely theoretical. The strongest and perhaps most damning critique of consent theory, or the notion of the consent of the governed, is the fact that at the time the government was formed, the framers ratifying the document, the state legislatures in the context of the U.S. Constitution, one by one ratifying the document, excluded women, children, African Americans, most of whom were at the time were slaves in the United States, and certainly excluded virtually every other person of color in the U.S., and most definitely excluded Indian tribes. And in the context of Indian tribes, the exclusion was not implied or just assumed, it was expressed. Indian tribes are written into the Constitution in the Commerce Clause, which lists 3 entities, one of which is included in the Constitution, states, another of which is most definitely not included in our polity, foreign nations, and Indian tribes, who are somewhere in the middle to some extent. So I always liked to contrast this notion of consent theory, which has troubled American political theorists for many years, for many centuries, frankly. I always like to contrast consent theory, the consent of the governed of the United States, to the practice of negotiating Indian treaties. I've read many stories and many histories of treaty negotiations, and in the state of Michigan, perhaps one of the most dramatic story of the treaty negotiation gone awry is the 1820s, when many of the Potawatomi tribes and the Ottawa tribes of southern Michigan traveled to some extent, at least their Ogamuk did, their leaders did, to negotiate an Indian treaty. And at the end of it, every chunk of land south of the Grand River, which runs from Lake Michigan over to Grand Rapids and into Lansing, south of the Grand River, was ceded by those Anishinaabeg treaty negotiators. The Anishinaabe guy, the Odawa guy who went down there to sign that treaty, was never authorized to cede any land whatsoever. He was authorized to go down there and receive presents, perhaps sign some sort of military or political alliance with the United States, but not to cede territory. For whatever reason, whatever the story might be, he signed on to a treaty that was a land cession treaty. And when he got home, his community was not happy with him, and they let him go. They fired him. And by firing him, I mean, and nobody knows for sure, they either exiled him or killed him right on the spot. This is not a good story for the notion of consent theory. And why I bring it up, because so many Indian treaties had stories like this, but so many Indian treaties, at least on the tribal side, involved fairly close to what we would consider to be a very strong idea of consent. The treaty had no validity within the Indian community unless the community itself consented. We often say that tribal communities are communities of consensus. And if you don't like it, if you don't like the outcome or you don't like the way things are going, you can always leave, and whoever's left forms the consensus. But nonetheless, there was a sense that I think at least in the Michigan and Anishinaabe communities, and probably the vast majority of Indian communities, everybody had a say. People who were men, people who were women, even people who were children, and in some, I think it's fair to say that in some, at least Indian treaty negotiations, even animals, inanimate objects had a say, and they were part of whether or not this was to be consented to. We have a phrase that we use in Michigan. I'm trying to make it used more, but it isn't always used. The notion is Mano B'madzuin, which basically just means well-being. So you might go up to somebody and say, Ni Mano B'madzuin na, are you feeling well? And really what that means is, at a fundamental level, it's a way of being, it's a philosophy, it's a constitution. It just says you're supposed to do things the right way. And it's a description of the world. And it starts with an individual, perhaps your soul, your inner spirit, and it expands out in circular ways out to everything, to include the entire universe, and that there is a connection that every person has with everything else. And implicit in treaty negotiations, definitely in Michigan, if you read some of the treaty journals and you hear the oral histories of the internal deliberations of the treaty negotiators between the people who were the speakers on the Indian side, amongst each other within the tribes and with their families and with their communities back home, implicit in all of those stories and histories and discussions is a recognition that there is a stewardship that Indian people hold to the land, and that there is an interrelationship between what Indians were doing on the land, within the sea, within the rocks, everywhere. All of that is part of the treaty. All of that is part of whether or not going forward the treaty would have viability. If it was a treaty between a group of Indians who had no such authority, who could not speak for anyone but themselves, then the rest of the community or rest of other communities would have no say, would have no interest in that treaty, would not be viable for them. So most famously, there's a tribe really in the northern part of the state of Michigan called the Burt Lake Band of Ottawa and Chippewa Indians. They should be federally recognized, Mr. Assistant Secretary, although it's not really up to your decision, I suppose. But they should be, and for lots of historic and political reasons they're not, and frankly legal reasons. And one of those reasons is they went to a treaty negotiation in 1855. They didn't like what they saw. They refused to sign, and they went back home. All the other tribes surrounding them, for the most part, signed on to that treaty in 1855. They're federally recognized. I shouldn't say all, most. All right, so I think that in the context of consent theory, the stories of Indian treaty negotiations bring to us what consent theory really could look like, or what consent actually could like, consent of the governed. But now we have, as sort of our American political theory, sort of undergirding everything that goes on in the United States. Consent theory is applied to Indian tribes as well, even if there was never any consent whatsoever. So I've given you examples how an Indian treaty might not work out, about some individuals or bands or groups could be excluded from a treaty because they refuse to consent to it, and what that means for us going forward. Some other treaties had different stories. Most famously and notoriously, how the United States negotiated with the Sioux Nations in the 1870s. And you can just look at acts of Congress setting appropriations based entirely on whether or not appropriations for food and whether or not they would sign on to ceding additional lands. I don't know that any other United States, I don't know any other government that would so boldly put within their operating legislation, within an act of Congress, you're going to sign on to this agreement or we will starve you to death. The United States did that in the 1870s repeatedly. And then, of course, there's unilateral abrogation, where the U.S., an act of Congress, or perhaps even a presidential executive order simply abrogates a treaty, and then without the consent, of course, of the other side, the parties to the other side. So consent has a long way to go. And as, again, the Assistant Secretary, it was a fantastic speech, mentioned, consent is not the same thing. Consent looks a lot like veto to some extent. But, the United States is not there yet. And we may not get that in that direction. We may not get there in our lifetimes. And perhaps that's something to aim for. Consultation, however, is a very real thing. It's a very important thing. And strongly urge, and I believe what Mr. Washburn said about making sure that you force the various federal agencies to acknowledge their consultation obligations. And I guess I'll close with a final irony. Consent theory in Indian law, especially at the Supreme Court, is a real thing as well. But it is being applied against Indian tribes. And I urge you to take a look at, if you want to know about consent theory and how it can be used in a fairly hypocritical way, take a look at the opinions of Justice Anthony Kennedy in Indian law. Most notably, going all the way back to the 70s, his opinion as a Ninth Circuit judge in the case that would become known as the Oliphant case. His opinions in Duro versus Reyna and United States versus Lara. He firmly believes that no non-Indian could ever consent to tribal government. And I just want to leave you with the idea that consent theory can be real. Indian people consent to tribal government. They vote all the time. Accountability in smaller Indian communities is a very real thing. There is consent theory in the United States. It's just not actually the United States. But that said, there is a lot to be said about the United Nations Declaration, and as a statement of policy, and as certainly as good practices, best practices. I hope we'll hear more about that in the rest of the panel, the rest of the day, and I thank you very much for allowing me to speak.
Tim Coulter.
Well, thank you very much, and I'm glad to hear Professor Fletcher's remarks, because they provide some good examples for what I'm about to speak about. I'm very glad of this chance to be here, but I am, and maybe the reason I'm glad is that I'm really profoundly concerned about the concept of free, prior, informed consent, and about the way that it's typically treated in connection with the rights of indigenous peoples. I think that it's likely to result in serious harm to indigenous peoples, to Indian and Alaska Native nations in this country, unless we change fundamentally how we deal with this concept. What does it mean? In my dark moments, I think of it as just a noun with three useless intensifier words attached. It's not really a principle most of the time. Well, what is consent? Consent is an expression of agreement or willingness that an act or something shall take place that would otherwise be a violation of a right. It is not a substantive right in itself. The right to grant or withhold consent is merely a procedural right that is inevitably and solely an incident of some substantive right. And I believe it's a profound mistake to treat it as if it's a freestanding right. It's essentially meaningless without a substantive right to which it attaches. To say all this another way, free prior informed consent is the act of giving up or compromising a legal right, a human right, usually only temporarily or in part, but sometimes absolutely, completely. When consent refers to relinquishing or compromising fundamental rights, human rights, it is likely to be a bad thing. Most human rights are regarded as inalienable. Why are we embracing the idea that consent to relinquish them, even in part, might be a good thing? Well, there is a place for free prior informed consent, and I'll get to that. But I think that when we see such an idea presented in a way that invades or alters or relinquishes human rights or fundamental legal rights, I think we should be on high alert for a multitude of possible harms. But instead, I see lots of people around the country and around the world that seem to feel that free prior informed consent, whatever that is a good thing, that it's somehow beneficial in their view. Frankly, I don't get it, and I don't believe it's true. In fact, I believe that free prior informed consent has become a formula for getting around and overcoming the rights of indigenous peoples. It is the shibboleth that multinational corporations, mining companies, oil companies, timber companies, and countries, their governments, hope to use to open the gates so that they can get hold of indigenous lands, resources, and perhaps do away with their governments as well. And so we, as lawyers, as advocates, as some of you I think are Indian leaders, well, why are we giving primary attention to giving away, evading, waiving, bypassing, and overcoming Indian rights rather than safeguarding, clarifying, strengthening, and promoting these rights of indigenous peoples? It's not that we shouldn't look at this at all. It's more a matter of how we look at it and what we do about it. So that's why I say I'm glad to be here, even though I'm alarmed about the concept itself. That's a good reason to be here and a good reason why we need to think about these things. Now, sometimes, and probably most of the time that free prior informed consent is spoken of, it's not a right at all. It's not a right, it's not a principle, it's just a noun or a concept. As it's used in the UN Declaration, free prior informed consent is not a right at all. The UN Declaration contains no right about free prior informed consent, period. It's a misunderstanding if someone tells you otherwise. The term appears 6 times in the Declaration. Article 10, it forbids forced relocation, and so the reference to free prior informed consent is nothing but redundant. It adds nothing to the article. Article 11, dealing with takings of cultural, religious, and other property. In that article, the term merely helps to define what the wrong was that needs to be redressed. Article 19, calling for consultation in order to obtain their free prior informed consent. Well, that clearly doesn't express a right. It only expresses the policy objective that one should seek free prior informed consent, but you don't have to do it. You have to seek it, but you don't have to get it. Article 28 refers to redress for lands taken without free prior informed consent. In other words, the term is used merely to define a prior wrong. There's no principle involved. There's no right involved. Article 29 deals with storage of hazardous waste in indigenous territories. It prohibits that as a general matter, but it does permit, it does make an exception if the indigenous people concerned give their free prior informed consent. So in that article, it's merely an exception to a general prohibition an exception to a general protection against a wrong. Article 32, the final one, again, it's consultation called for in order to obtain the free, prior, informed consent. The consent is not required. It is not what I think of as a right. And by right, of course, I mean what ordinary people mean by a right. It means a rule that can be enforced, that requires usually a government to do something. I don't mean, when I say right, something we just want. I mean a legal rule. Now, that, I think, I'd like to hear the argument to the contrary, but I think that nothing in the Declaration creates a right of free, prior, informed consent in any meaningful sense. Whether it's a right or merely a concept, it's a mess. It's so poorly defined or not defined at all that it's practically useless, and worse than useless, it's treacherous, it's dangerous. If you don't know what it is, you better find out or you better stay away from it, because it's going to be a problem, or it's likely to be, because we're dealing with very fundamental and valuable rights. Some of the problems: who can give the consent? Matthew already gave us some examples of that problem. What constitutes consent? How is it to be expressed? How do we know it is free, that it's not coerced, that it's not under duress or corrupted? When is it informed? All of these questions need answers, and in practice, nothing will really suffice except monitoring by some independent body. That has been the experience of the world with regard to the protection of human rights, and we are going to need monitoring about this as well. I think the concept of free, prior, informed consent is an unlawyerly, poorly thought out concept. In my experience, I should say in our experience, it's a concept that seems to have come from environmentalists, bless their hearts. Usually those working in other countries in Central and South America are the ones that we're familiar with. And it seems to have arisen in situations where these conservationists or environmentalists didn't have the courage to express or state that the indigenous peoples concerned have actual legal rights to some land, some resource, or the right to do something such as exercise a right of self-determination. They didn't dare do it. They feared that they would be kicked out of the country if they said such things. They feared the political ramifications or the practical ramifications if they stood up and said the right thing. So they used this euphemism. Oh, well, there should be a right of free, prior, informed consent, whatever the hell that is. That certainly sounds a lot better than, that land belongs to the Indians. What are you talking about? You know, you can't take that. That belongs to the Indians. Get out of here. They didn't want to say that, but I think in a lot of situations they should have considered it. I believe actually the Awastingni case was a case where that was said, where serious legal rights were asserted and the Indians won. The other thing the environmentalists did was to use this idea, this concept of free, prior, informed consent. This, I think of it as an illusory, it's a seeming right that isn't actually a right. They used it, and they still use it, in situations where no actual legal right exists. And sometimes that's not even wrongful. Situations where communities are being hurt, damaged, torn apart, because of, let's say, a huge mine on land that's right next to them. It's not their land. And this happens to non-Indian communities too. They're disrupted, they're harmed, their livelihoods are taken away and so on, but they don't own the land. What are they supposed to do? It's awful, and environmentalists and other social policy people have tried to come up with good arguments. So they came up with this idea of free, prior, informed consent, that, well, you ought to at least give these people the chance to block it if they don't give their consent. Kind of a policy soft argument that non-lawyers might make. Well, I understand, and that sure happens to Indians too. You know, there are times where the Indian land title has not been established, where it isn't possible to prove that that legal right exists. And it's defensible, I think, to sometimes use a makeshift argument when you don't have the hard argument available to you. I'm sympathetic to that. We've all done it. We'll fight with a shoestring if we don't have the real thing, you know. That's okay. And that's what I mean by a place. There's a place for free, prior, informed consent. It can be used. And as I said, the other place for free, prior, informed consent is that certainly it is an incident of other substantive rights. In other words, it's an incident. It's one of the bundle of sticks. Don't you hate that by now? It's one of the sticks in the bundle of property rights, resource rights, and the right of self-determination in particular. Probably other rights too. But it's only incidental. I don't believe it has any real freestanding meaning. Well, I think it's really misguided and it's confusing when free, prior, informed consent is dealt with as if it were a substantive right and as something beneficial in itself. I think it's analytically and intellectually backward and awkward at best. It's, I always, a simple-minded approach. To me, it's like looking at the hole instead of looking at the donut. We need to look at the donut. We need to look at the thing that matters. I like donuts anyway. Many people, especially non-lawyers, do believe that this is a substantive right that deserves praise and it ought to be embraced, blah, blah. I don't think so. I think that approach is misguided and misinformed. Often, I mean, really lawyers have gone along with this, especially in the international community. Anyway, I think we need to think it over and try to do as much as we can to change that, because really, I can't think of another field of law, another area of human rights, and maybe you can, but I can't, where it's the process of giving up the rights rather than the content of those rights that is focused on. Why do we do that? Why are we concerned about the giving up of the, well, I know why we're concerned about the giving up of the rights, but why do we focus on it? Why don't we focus instead on trying to strengthen and clarify and improve and protect the rights? Now, what do we need? I don't want to be just all negative. If free, prior, informed consent is often misused and misunderstood, what would be right? What would I recommend? Well, I think we should be fighting for and talking about and trying to strengthen and advance genuine, substantive legal rights. These legal rights, number two, need to be defined in a straightforward legal way, in straightforward legal terms, not with newfangled, unique baloney. Well, really, we need real, ordinary law applied in this field. We need the rule of law. We need a society, a country, and a world that's governed by law, not arbitrary stuff, not fake, illusory, funny ideas. We need rules that can be enforced and that we agree on to begin with. And we need to have effective judicial remedies. That's what I mean by enforcement. Well, that's it. Thank you.
Calvin Lee.
Yeah, I've been a good morning. I'm Calvin Lee from the Navajo Nation Legislative Branch, the Human Rights Commission Office. And I'm very pleased to be here. I think this is a exciting topic. I don't really use the word aspirational in talking about the UN trip. I think it's inspirational. I think it's inspirational because I think there are some parallels within the Navajo Nation and our own judicial branch and some of the things that they've done to try to draw upon what they call the fundamental law, which maybe if some of you have studied, goes back to the common law, the natural law, customary law, traditional law, all of that comprise our fundamental law. So since I've been in practice and I started working with it, and you do have to work with it in Navajo Nation courts, the judges will make you work with it. And so the legislative branch, I think, also tends to make you work within that, as well as the Navajo Nation Code. I've only known Special Rapporteur, Mr. Anaya, Professor Anaya now for a little less than a year, but I find what he has to say about the topic to be also very interesting. And some of the things our office have done, utilizing the UN DRIP and other international standards, has been, for me, I think, really exciting because we put it into action and try to do so as much as possible. So one of the things that I've done is also look at the UN guiding principles on business and human rights, because I think that's something that is important to the Navajo Nation and the people, because the history, beginning all the way back to the formation of the council, began primarily because government needed to work hand in hand with the oil and gas industry to get together some people who would represent the nation to sign off on leases. So it started from 12 maybe to 20 to larger and larger number of delegates added on, going all the way up to 88 delegates. And of course, within the Navajo Nation, that had resulted in a lot of, I think, some dysfunction and complaints. So they eventually had to downsize per the people's will. And so we had 24 delegates. I think the people basically were not being respected, but it was through the courts that they had to finally enforce what they had expressed. They did want the council to be reduced. And so, of course, now our council deals a lot more with, leases. There's a wide range of things that they do. In 2006, we had an incident where a young Navajo was shot and killed by a Farmington police officer, and that what led to some investigation, a lawsuit. The council, under the leadership of our speaker, Lawrence Morgan, had started the commission. And I think a number of grassroots also felt that it was important. So when the commission began, it was one of the first things they would look at was the relations within these border towns and the people. And so that's something that's, I guess, sort of the bread and butter of the office, to keep working on that and working on MOUs to foster better relations, primarily in the area of consumer, but also civil rights. And that has led to a number of MOUs. We have an MOU with City of Gallup, City of Farmington, City of Winslow recently. We're working with the police departments also and trying to train them to also understand some of the finer nuances of the Navajo people, the language, the culture, and understand what they can add into their policies and training. We have 5 commissioners, one of whom is a former police officer, Mr. Frank Bradley III, and he's also made himself available to provide some training to some of these officers to help them in their training manuals. The AZ Post is the certifying agency, and he's allowed to teach and even if necessary, even propose some additions to the policy, to the training manual. So that has really, I think, made some inroads in bridging the gap. And basically, it goes back to understanding. I think all of this that what we're really talking about is basically putting people together, and that's what we've done in emphasizing the UN DRIP or the UN guiding principles. And one of the other areas that we talk about is the consumer area, where we have so many of our people going into these border towns and spending easily $1 billion a year. And all of this money comes from, the federal government, through the agencies, BIA, IHS, the Navajo Nation government spending as well, and of course the consumers. And so a lot of that, I think, tends to go off the reservation, and just, we miss the multiplier effect, the economic benefit of having all of that. So in trying to bridge the gap and utilize these tools, I think it helps to, when there are disputes, put the owner together with the buyer and just hash it out. And the lawyers tend to we have to step back and try to facilitate some of this discussion. We had some students this past spring from the University of Denver Law School show up, and they were all they had been studying international relations or international business transactions, so they were a great addition to the office. I like having their help around, so we put them to work, and one fellow we put to work, Michael Smith, was really great. I think we went on a number of trips to dealerships and worked with them to emphasize what we need to do to address some of the complaints. We even got on the radio even, and I think he expressed some of the things that he had also learned. So it's one of the endeavors that I think, again, it's exciting for me because we see things start to become resolved right before our eyes. And now we've probably resolved, I think, and recovered at least $200,000 for people just in the auto area alone. But there's been a number of things that this office has done. As I mentioned, we worked with Professor Anaya. Mr. Coulter is also a frequent visitor to New York with our executive director and working on a number of these things. But I mentioned the special rapporteur because in one of the most recently published guides, and I should mention, we also had a meeting recently in Flagstaff with the UN Working Group on Business and Human Rights, and Mr. Pooven Selvanathan is the chair of that group. And he heard some of our issues that we brought out, not only about sacred sites, the peaks, but also about the consumer issues and some of the people that are driving it. Big transnational companies like Santander, Banco Santander, which is based out of Spain. So that was a really interesting experience for us because we emphasized, again, the UN DRIP, the standards, the international norms. I think that was something that was kind of new for me, and they were receptive. Again, it goes back to this communication, the understanding, but it's been useful to go back and again, hear from someone like Special Rapporteur, as he has published a number of things that really, I think, give more guidance, more lucidity to this. And so when I look at this most recent draft of a report that was recently published here on free, prior, and informed consent within the context of business and human rights. The concept of free, prior, and informed consent is fundamental to the UN Declaration as a measure to ensure that indigenous peoples' rights are protected. The UN Special Rapporteur on the Rights of Indigenous Peoples, Professor Anaya, states consultation and free, prior, and informed consent standards are best conceptualized as safeguards against measures that may affect indigenous peoples' rights. Other such safeguards include, but are not limited to, carrying out prior impact assessments, the establishment of mitigation measures, benefit sharing, and compensation for any impacts in accordance with international standards. The concept of a state's FPIC obligation is well enshrined in international law. The UN Declaration creates an expectation that governments will seek the FPIC of indigenous peoples for development projects. In 2007, the Inter-American Court of Human Rights interpreted this to require the government seek the FPIC of indigenous and tribal peoples before undertaking development projects with significant impacts. And as Mr. Coulter mentioned, there are at least 6 places in the UN Declaration where it mentions FPIC, the removal and relocation of indigenous peoples, which is something important to the Navajo people. We recently had a meeting with some folk from the OMB in Washington discussing perhaps shutting down Office of Navajo Indian Hopi relocation, and it's been one of Senator McCain's projects to do away with that altogether. And we tried to stress that essentially this Navajo Hopi Indian Relocation Act really should not have even come about. It really should have involved more discussion among the peoples themselves, but I think there's probably a lot out there on the web if you look at some things that talk about, this phony war having been created between Navajo and Hopi in an effort to do the old divide and conquer thing and try to, separate out some land in order for a big business to come in and do their thing. And so I think the group that came from OMB decided that they would go back and take a lot of the things that our commission chair, Mr. Steve Darden, a former Flagstaff municipal judge, had expressed about the legacy of turmoil that the act has caused, and a number of families that have not benefited from this, like those that were displaced and put in the Sanders, Arizona area. They were supposed to obtain some economic benefit out of that. They have yet to really see any of that. And so I think we try to express that. The act itself really wasn't a good idea, but to do away with it altogether, that should be something that we should have a close discussion about and determine what would be the most appropriate step, not something that's just merely politically feasible. The taking of cultural, intellectual, religious, or spiritual property, that's something that has come up recently in some of the complaints that have been brought to our office. That's usually how things get started. People go online or they come into our office and fill out a complaint, and then we get started doing some preliminary investigation, and if it turns out there's this is something that is within our scope, we'll go ahead and do some further study, even if it means going all the way back to ask for some more funding from the council to do some measures that might include litigation. But we had some issues where people had come and said, well, my area, my customary land use area was bladed over because of some group that came in, and we see this a lot, joint ventures where it's a small group of Navajos, maybe even just one person that enters into a joint venture with a large transnational company. So they're hanging out in the background, but what we're really looking at here is supposedly a Navajo project, and this is what they want to do. They don't always obtain consent. In the Navajo context, that usually means you go to the local government unit, the Navajo chapters, which we have 110 of them. You go there. It's essentially like a town hall almost. And that's where you obtain your consent, usually in the form of a resolution. Well, they didn't get their consent, but they found their way around that. Through their help from media and other polling people, they went out and expressed that, oh, well, we got the consent. Here's our focus group. Here's our other studies that we've done. Essentially, steps were not followed. It appeared our government has a lot of 638 contracts. Our Historic Preservation Department has a 638 contract, so our Tribal Historic Preservation Officer has quite a bit of clout in determining whether a project should go forth or whether it should be scaled back. Basically, they have some recommendations that they have to make in terms of remediation. And so we got them involved more so, and I think that really helped to, address some of the concerns that the people had, that somebody was listening to them, that government is working, and that we're going to have some input and determine how best to rejigger things if necessary. And if the project can go forward, great. If it cannot, that's just the way it has to be. But we have projects like that. I'm sure other Indian nations do too. The Confluence Project is another one people might have heard of. Where they talk about doing a tram from the top of the Grand Canyon down into the lower reaches there where the river is, and of course a number of people regard that as sacred, not just Navajo but Hopi, Hualapai, and the Park Service had a problem with it also. It's another type of idea that was hatched, but probably might have to be taken a step back. And as I understand, they had some other plans that they brought forth to President Shelley, but this is another area I think that, again, we come in to bring these issues out there, FPIC, UN DRIP, or even our Navajo Nation fundamental law. The third area, adoption and implementation of legislative or administrative matters that may affect indigenous peoples, Article 19. I think that is something that we have, addressed, or at least made mention of. I recently took part in a amicus brief we filed on behalf of a defendant in the 10th Circuit, a criminal case in which he used Navajo in the interrogation process. That we felt wasn't adequately translated, but it shows up in the transcript as something that's slightly different from what we think is the actual translation. And then, of course, when it goes to trial, that transcript is utilized. And again, we're also looking at the other problem where you have a mainly white jury. There was 2 trials. There was actually a trial where in the first trial they had a Navajo on the jury, but in the second, they lost that, but they brought it back again. And the U.S. Attorney's Office brought it back again and brought charges again the second time around. And there we had an all-white jury. So in the federal courts, we also have interpreters, but these interpreters, I don't think are always paid much attention to. If you use Navajo, I think as a criminal suspect, then that, I think, starts to bring about some duty and obligation to try to get it right, because it becomes part of the record, and it could be something that really just isn't paid much attention to, quite frankly, after, as you go down through the course of a trial. But I think that was something that was very important to bring about. We wrote a brief, and like I said, we mentioned FPIC, we mentioned the UN DRIP, we mentioned some other international covenants and declarations, but I think at the very least, it got the conversation started. The confiscation, taking, occupation, use, or damage of indigenous people's lands or territory, that kind of touched on that. That comes out of Article 28. The storage or disposal of hazardous materials on indigenous people's lands or territories, Article 29. That's something I think our council has been concerned about. Like, again, the history of Navajo Nation is, energy. We have right-of-ways, oil and gas lines, we have waterways, we have power lines, we have all kinds of stuff crisscrossing the Navajo Nation. And so I think there was an issue that came out where one of our delegates expressed some concern about hazardous waste being transported across, and that we perhaps need a permitting process, something to regulate that. And that it didn't really draw so much upon FPIC, but I think the notion was there, and we have some of our delegates working on legislation bringing that forth before the Navajo Nation Council. Lastly, projects affecting indigenous people's lands, territories, or other resources, particularly in connection with the development, use, or exploitation of mineral, water, or other resources. Article 32, I think that's really important because last year the commission had a complaint come before them from a grassroots organization, Asst, it means the vigilant ones in Navajo, and they expressed that they had some real problems with this Senate Bill 2109 sponsored by Kyle and McCain. And that was intended to try to settle the water dispute, the whole water claims, water rights of the Navajo Nation. And I think initially it came out that, well, we're going to bring this to the people, is what the president said. We're going to let the people decide. We're going to have these essentially public forums. Well, it turned out the idea had already been essentially agreed to in principle by our attorneys representing the Navajo Nation. So I think that really drew some people into a bit of an uproar, but they did bring the complaint before the commission, and the commission at the time, chaired by another longtime civil rights and Navajo Nation leader, Dwayne Chiliazzi, now the chapter president at the Shiprock chapter. And he expressed very much so that there's a problem here, and he wanted to get that across, emphasize it. I was going to put this up on the PowerPoint here, but I'll just kind of read to you what went into the commission's resolution briefly. The commission stated, one of the fundamental standards of indigenous human rights recognized by the Declaration is that when land, territories, and other resources are to be taken, indigenous peoples have the right to free, prior, and informed consent. And then they went about explaining that further. In paragraph 8 of their resolution, it stated, the United States Senator John Kyle introduced Senate Bill 2109 entitled the Navajo Hopi Little Colorado River Water Rights Settlement Act of 2012. While the bill is intended to permanently settle the water rights of the Diné and Hopi peoples as it pertains to the Little Colorado River, it also contains provisions stating that the Navajo Nation will forever waive any other water rights claims The Navajo people were not informed of the proposed settlement until April 2012, when the Navajo Nation Water Rights Commission conducted several public meetings only on the Arizona side of the Navajo Nation. And in order to fulfill the International Human Rights Standard on free, prior to informed consent, adequate time be set aside and information be disseminated in a transparent manner to the Navajo people in order for the people to fully understand and comprehend in their own language the content of Senate Bill 2109 and the settlement agreement. The Navajo people are being requested to respond in a short time frame to a weighty legislative measure that affects them not only on a daily basis but generations into the future. Placing the Navajo people in a position to respond to a complex legal issue without freely informing them in advance and making decisions based on a transparent process is violating their right to free, prior, and informed consent, the human rights standard applicable here. So that resolution, I think, really kind of turned things around. It was really the turning point where the Senate 2109 didn't have much legs after that. I guess you could say there was some enforcement, but it was done so in a court of public opinion. So, and that's really where I think a lot of this really also goes back to. You know, again, I can make parallel, like I said, to the Navajo Nation fundamental law. Well, what is that? It's what you learn when you go to Mass on Sunday or wherever you go to. It is the moral law, essentially, the ecclesiastical law. In our Navajo fundamental system, our laws go back to our value systems. That's where things have to, I think, ultimately go back to, and people need to confront it because, you know, as an attorney, I know, we don't have a whole lot of faith in these laws. These laws that were meant to protect indigenous people, Indian people, they've been subverted, every single one of them. It's like a natural human tendency, apparently. If you create a rule, quickly find an exception to it. Find a way around it. Do something that you can, you know, be crafty about to get it subverted. A lot of this, like I said, it's really something that is exciting for especially the young law students to really try to find some way to not so much put this in legal terms. I guess you have to be somewhat creative to figure out just what would be the best instrument, what works best to make the FPIC make a difference. So I leave that to you. Thank you for listening.
Rebecca Tsosie.
Good morning. I am very pleased and honored to be here. Thank you so much to Kristen Carpenter and Carla Fredericks and my wonderful colleague, I see Charles Wilkinson. Thank you so much for the great work that you do on behalf of all Native people. It's really wonderful to be here. The panelists who have gone before me have made some wonderful points and some caveats and have set the stage, I think, very well. And in the time that I have this morning, I will play a very humble role, which is to basically link up some of the ideas that have been presented on this foundational panel to the many wonderful topics and panelists that you will hear from in subsequent panels. And I'm actually just amazed at the range of talent and commitment and dedication that is represented by the people that are at this conference. So thank you so much. I want to talk about the implementation of the notion of free, prior, and informed consent as being sort of a norm that is embedded within the Declaration and somehow needs to make its way into domestic U.S. law. And I want to start by saying that all of the caveats that have been expressed are very well-founded and very complicated in the U.S. because we're so accustomed to finding some sort of a foundational document that can guide our existence. And we do that with the U.S. Constitution. I actually am teaching constitutional law right now as one of my other subjects. I'm teaching constitutional law too, which is the whole Bill of Rights. And the first day in class, I usually poll people for their intuitions about what rights they have. and then we look at what the Bill of Rights says, and then we look at what the court says in these different intervals, and maybe you have a right and maybe you don't have a right, and maybe nobody knows what exactly a right is. And that's one of the big problems. So if I could just build on something that Calvin Lee just said about Navajo Nation fundamental law, and I think there is that spirit that drives people to want a moral context for the legal right that they express. And yet in federal Indian law, many times the moral intuitions that Native people have that are founded on their traditional law are not recognized by the dominant society. And so there's always a struggle to find whatever the Charter of Rights is that's going to get that into U.S. domestic law. Well, is the U.S. Constitution going to do it? Probably not, because they're not parties to the Constitution. And that was the whole idea for treaty constitutionalism as sort of a rubric. But as my colleague Matt Fletcher explained, the historic context of those treaties for anybody that studies that is highly problematic in terms of a moral charter. Later on this evening, you'll hear from our wonderful colleague, Walter Echohawk, in the context of his newest book. And he talks about justice, and Charles Wilkinson has talked about this in his many works. Well, where does our concept of justice really come from? And what does that mean for our discussion today? So I think that a lot of Indigenous peoples are looking at the Declaration as a charter of justice that can open the dialogue in domestic law. And Calvin's presentation, again, about the water rights settlement was very important. When I talked to community leaders in Arizona, in the Southwest, a lot of them think the idea of free, prior, and informed consent is a moral right that should be a legal right, and that they probably just need to hold to that line. And so the idea, as you saw that in the Declaration, it's really only express reference in 6 places. So Tim Coulter, you're reading that correctly. It sort of acts like a limiting principle in the ways that we as lawyers are trained to think, right? Because if a constitutional provision only has some, and it's not in every other provision, then we tend to think, well, it's only confined to incidents of relocation, or it's only confined if they're situating toxic waste on your land, or that's only. So what about the broader principles that it stands for? And so that's what I really want to focus on is the idea of that as a norm, the way that Indigenous communities would want that to operate. Okay, so that's what I'm going to do in the brief time. If I don't make any sense, give me a wave. I'll sit down. We'll open it up to questions and answers. But that's what I really want to engage. So first thing, structurally, about the UN Declaration, I think it is a very interesting document because it talks about the rights of Indigenous peoples in 2 senses. And they're both premised on the idea of equality. First of all, they are peoples that are equal in status to all other peoples, and they have the right to self-determination, as Tim Coulter said it, and thank you so much for the wonderful work that you've done framing that. But they're also individuals within nation states that have suffered a history of discrimination, oppression, and they need to be equal citizens within those nation states and have the right of participatory democracy in their constituent identity as citizens. So there are a number of provisions that talk about the human rights of individual Indigenous peoples as well as their collective rights to self-determination. And sometimes they start to get conflated, right? Because the government will think, well, if we're honoring their equal rights as citizens, say in terms of religious freedom, right, that's an individual right, then what's this collective right, and what does that have to do with it? So that's one of the issues that we have to engage. The principle of consent, interestingly enough, intersects with the right of self-determination as it is expressed in Western philosophy at any rate, in terms of an individual's autonomy interest. So that's the Western philosophical notion of consent, is that it's related to your individual autonomy, your liberty interests, you can consent to certain things or you can, reject those things, and it becomes worked as a moral principle into the law in very interesting ways. Assistant Secretary Washburn talked about the criminal law context, so that's a powerful repository. Also, medical care decisions, right? I mean, there's an ethical requirement to get informed consent, but that actually has made its way into the law in recent years in terms of privacy interests, blood samples, inoculations. So the bundle of constitutional rights has now mapped onto that in terms of the individual. Well, what about the collective? And it turns out that self-determination is the moral right in international human rights law that undergirds the political right of a people as a collective to define its destiny. So they run on parallel tracks. So the people then has the right to consent to the terms of its governance when it is in association with other governments. And that's the whole magic or potential magic of equal status as peoples under international human rights law, because those relationships were reconstructed post-World War II in the context of decolonization. Well, so does that whole scheme then get transposed onto the internal structures that nation states have established with their so-called indigenous peoples? They're not their peoples, but that's where they are, physically located. And I think that the Declaration sets up some very interesting material for us to engage about what the conditions are of equality as peoples. Now, one of the things that I do want to call your attention to is that there's a feature of U.S. jurisprudence that is heavily mapped onto 19th century moral philosophy too. And so in the work of John Stuart Mill, for example, in his work on liberty, and when he talked about justice, he said it is an injustice if an individual's moral or his legal rights are violated by the government. That is what we know as injustice. And he actually talked about the groups that could be managed by the government without respect for their autonomy, and they were those of diminished capacity, so children, mentally incompetent people, and uncivilized people. And that was the doctrine of justified paternalism in moral law that then got transposed onto the indigenous peoples through the policies of the Western colonial nations and their descendant nations, the settler nations. So that paternalism is said to be consistent with the rights of autonomy as they are recognized under Western moral principles. Now, what does that mean for us today? Well, in federal Indian law, we have to engage the role of the trustee. And so we're going to have panels talking about land. And in this respect, I would say that the Declaration needs to be read on two tracks. The Declaration talks about redress for that which has gone wrong, has been an injustice in the past, unlawful acquisitions of land, cultural property, what have you, right? Redress for that, and free, prior, and informed consent serves as a principle for repatriation, restitution, or compensation where neither of those is applicable. But the second thing is forward-looking. So it talks about the fact that we're going to now have new practices. We are going to renegotiate those relationships on conditions of equality, and that's where we're talking about what procedures need to be factored in at the federal level now under the trust relationship. So the norm of consultation is firmly embedded, but we know that that does not entail a veto responsibility. So one of the challenges I think that we have, and I'm just going to sort of highlight where this is going to go in the future, is first of all to recognize that the world that is opened by the Declaration is bigger than the world that is defined by federal Indian law. The world that is defined by federal Indian law has been narrowed by paternalism, by the trust, and by the Indian Claims Commission. All of those processes that are said by the United States to have served procedural justice, but as Tim Coulter says, they didn't serve substantive justice. So now we have to recalibrate the substantive rights. And it would be a mistake, as he points out so brilliantly, to conflate the procedural obligation of free, prior, and informed consent, which is an ethical principle, a norm. It would be a mistake to conflate that with the range of substantive rights that needs to emerge in this new era. So here is a list of things that we could think about in terms of that norm. First of all, the idea of the right not to consent. What is the meaning of that? And here, I think that we have to look at the cases, and Matt's work is phenomenal on this issue. What is the Supreme Court doing right now with the principle of consent, and how is that affecting the rights of tribal citizens within their nations and vis-a-vis the citizens of the exterior entities that they intersect with? Secondly, the distinction between moral and legal rights, that comes up in international repatriation, as we saw last summer with the Hopi masks that were auctioned off in the Paris auction house, and people had the nerve to say, well, it's only a moral claim. There's no law that actually does that. And when you look at the laws in international law, they broker international trade. And I think Preston Hardison and Susan are going to be talking about that in terms of intangible cultural resources, intellectual property, if you will. That is on the table. And in that respect, we have to look at the global environment, which is that indigenous peoples they are under the nation states. The nation states sit at the table in articulating treaties on climate change, on international trade that affects indigenous peoples. They aren't parties to it. What is the right of consent there? And who has it? That's the other thing about domestic law. It is confined to the federally recognized tribes, whereas the Declaration is broader. It talks about the inherent rights of all indigenous peoples. In Hawaii, the Native Hawaiian people are indigenous. They don't have a right to be consulted under the federal consultation protocols that map onto federally recognized tribes. There have to be special accommodations for them. And that is a problem, as Matt mentioned, in the context of tribes that refused to agree to a political relationship with the United States and are still being punished for that in terms of being omitted from this world. Also, we have to think about who has the right to consent within the multiple and overlapping relationships of tribes. So now historic nations, and there are people here, for Lakota people, I mean, they might be composed of all these different federally recognized tribes today, and yet they may have consistent cultural interests that need to be vindicated. In the context of different tribes who might sign on to an economic development project that jeopardizes the cultural rights of a culturally affiliated tribe that isn't the same tribe. So who gets to consent, and when is that binding for purposes of other governments? And what is it, finally, what does it mean to be informed? And people talked about that. Well, right now there are a lot of things that are going on in federal energy policy, for example, talking about new technologies in mining uranium, in siting toxic sludge from power plants in situ, pumping it down into the earth, different water projects. Well, all of those have implications, and they have implications for the people that are indigenous and still living on those lands. We recognize them to some extent when the tribe is the landholder because of the right to exclude. But as Kristen Carpenter has pointed out in her work, and also my wonderful colleague Angela Riley, so happy and so honored to be with both of you, we really have serious concerns in terms of the ancestral sites still within the customary use areas of Native peoples, as the Western Shoshone case indicates, and a constellation of mining projects that is global Those are global corporations, multinational corporations. How do indigenous peoples intersect with those commercial interests which transcend national boundaries? So those are the issues that I want to think about. I really thank you for your time. I know that I've run long, so thank you so much.
So, Kristen, how much time should we use for questions?
2 questions and then do coffee.
2 questions, okay. You have that, who has the microphone?
Oh, I do, sorry.
If you guys get asked a question, that thing that looks like a cockroach out there, that's a microphone. That's a mouse.
And needless to say, we can keep discussing all day, but this is an incredibly rich panel. But if you could keep the questions and answers short, then we can all move on to coffee. I'll let Rick call.
Hi, I'm interested in the moral context that's been referred to, and it's my observation that the moral context of the dominant culture is simply growth. There's lots of other things, and it's not that simple in a stated manner, but it is the driving force. And so it seems like that moral context is always going to be in conflict with anyone's rights, indigenous and other, and that when it comes, push comes to shove, as long as that's the way it is, everyone will lose. And I just want your feedback on that.
Who wants to field that? Oh, don't all stand at once.
I'll go ahead and answer that. I guess that's one of the things that I feel is important about the FPIC, is the UNDRIP, is that it does cause people to confront basically their inner demons. They have to try to maintain some consistency between what they understand to be morally right under their value systems, in addition to trying to rationalize what is right under the man-made law. But all too often, I think we do try to rationalize our way out or around the man-made law and then forget about the moral base, the moral part of it. So that's the kind of discussion that I think this tends to lead into.
Hi, good morning. My name is Jim Zorn, and I work with the Great Lakes Indian Fish and Wildlife Commission out in the Midwest on the ceded territory treaty rights. And Chairman McGeeshik from the Sakagan Chippewa community and I and the other tribes out there face interesting issues with the state legislatures. In Wisconsin, as many people may know, the legislature just revamped Wisconsin's mining law, basically at the request of a mining company, and the tribes' ceded territory rights are implicated. Could the panel please talk a little bit about the consent theory and practice in that context, where you have a legislative body at the, not nation-state level, but state level, may take an action, and where do tribes fit into that when the state claims they're just exercising their legislative prerogatives?
Thanks a lot. I'm from Michigan, and we you know, the 1836 ceded territory is in Michigan is part of what GLFLIC works with. So I'd like to add this idea, the notion that you can hunt down all the Mingan, the wolves, all their relatives that way, using state legislature is state law in ceded territories where there are treaty rights. Exposes, I think, very dramatically the limits of consent theory. Because under consent theory, the way we understand it in our American system of government, Indians have already consented to the hunting of all of their relatives because they're citizens of the state. They're citizens of the United States. And the state, if the state votes in its democratic process to exterminate wolves, and that you've consented to that. You're a part of that process. Now, treaty rights push back against that a little bit. Perhaps the UNDRIP pushes back a little bit against that. But ultimately, it just becomes a power play. And that I've heard some of the discussions of, you know, the negotiations with the tribes, tribal attorneys talking to state legislators who have no concept whatsoever of what it means as a matter of just culture, and to have the respect for a creature like a wolf in the context of what it is supposed to be doing, why it exists in our world, and what it is there to do. It's a clash of worlds, and this is where consent theory completely breaks down. And to say that Indians and the Indian tribes are part of this structure and therefore they've largely consented is essentially what the consent theory does for us here, and it's really damaging.
I can't resist commenting that you guys and others up in that area have just been doing a fabulous job of fighting. I think what law can do to help you is pitiful compared to what you're doing using facts and ingenuity and political leverage and organizing. I wish we could do more, but that's my bit. I'm afraid free, prior, informed consent isn't going to help you much. I wish we could do more to help. You guys are doing great, though.
We're going to have to try to get back on track, so thank the panel. Refreshments in the same place as this morning, and we're going to try to reconvene at 25 past 11.
What's that?
You ripped a consent to shreds.
Thank you so much. That was
Wow.
impressive. So good.
Well, it came from you.